Good morning and welcome to the program Defenders in India, examining the Elgar Parishad case. This webinar is presented by the American Bar Association's International Criminal Law Committee. The Declaration on Human Rights Defenders was adopted by consensus by the UN General Assembly in 1998 after 14 years of negotiations. Despite the declaration, human rights and environmental defenders all over the world continue to suffer significant harm as a result of their efforts to raise awareness on significant issues in their communities and within their states. This webinar will present the challenges that human rights defenders face in India, specifically focusing on the arrest of 16 activists, which included lawyers, sometimes referred to as the BK-16. And now to introduce our speakers. Suchitra Vijayan is a lawyer, researcher, and the author of the critically acclaimed Midnight's Borders, A People's History of Modern India. She is the founder and executive director of the New York-based research and journalism nonprofit, The Police Project. Her book, How Long Can the Moon Be Caged? Voices of Indian Political Prisoners, co-authored with Francesca Recchia, is forthcoming. Dr. Waris Hussain is the legal advisor for South and Southeast Asia with the American Bar Association's Justice Defenders Program. Prior to joining the center, Dr. Hussain was a policy analyst at the U.S. Commission on International Religious Freedom, covering the South Asia region. He is an adjunct professor of international law at the Howard University School of Law. Dr. Jenny Rowena works as assistant professor, Department of English, Miranda House College, University of Delhi. She has worked on caste and gender issues in popular Malayalam cinema. Her PhD thesis is entitled Reading Laughter, the popular Malayalam comedy films of the late 80s and early 90s. She is the author of Rowdies and Lords, Malayalam Cinema and Masculinities. She is also the wife of Bhima Corrigan arrestee, Professor Hani Babu. Father Joe Xavier currently serves as director of Indian Social Institute, Bengaluru. He holds a master's in human rights and a PhD in human rights and criminology. From 2001 to 2007, he has worked as the Secretary for Jesuits in Social Action in South Asia. From 2012 to 2015, he served as the Executive Director of ISI Delhi and the editor of Social Action, a quarterly journal, and as a Deputy International Director of the Jesuit Refugee Service, Rome, from 2017 to 2019. He has authored 5 books, published over 10 articles in well-reputed journals, and conducted half a dozen evaluation studies. He was a close associate of Father Stan for the past 20 years and accompanied him in the last 2 years of his life. For our audience today, we will be hearing from each of the speakers, and then we will have a question and answer session. Please put your questions in the chat or in the Q&A, and after the speakers have each had a turn to address you, we will get to your questions. So to start, Suchitra Vijayan.
Susan, thank you so much for organizing this, and everybody else at the American Bar Association for putting together these conversations, because these conversations are important ways for us to not only acknowledge the important work people like Father Xavier and Varis and Professor Jenny Ravina do, but also acknowledging the bravery and resistance of the political prisoners in India. Today, I'm tasked with introducing the BK case and what's happening. And once you really think about it, this is going to take us entire lifetimes to actually understand and interrogate what's happening. So rather, what I'm going to do is keep it brief and give you a very a simple outline of a few things that have happened that might help us understand the nature and extent of impunity that has been employed by the Indian state against some of its most brilliant scholars, writers, thinkers, and those who have stood in solidarity with the country's most oppressed and continue to fight for them. So long before we get into the BK16 case, I think it's very important to understand that BK16 and the arrest of human rights defenders and activists and scholars didn't happen in a vacuum. It was made possible through a long history through which the very institutions, law, order, judiciary, and various other institutions were consistently eroded over a long period of time. And this was done in many ways. One of the ways in which it was done is creations of extrajudicial and draconian legislations like the UAPA. While the UAPA was first put in place, introduced in 1967, over the years through various amendments, what really happened was that we've made this law not only a law that is called the terror law or uses sedition. What it really does is that it creates a regime of impunity, wherein you have a series of laws that can unilaterally designate people as terrorists without evidence. Some of the other things that the recent amendments did was basically make bail impossible. And what is really done is that it is given immense power in the hands of the ideological foot soldiers of the BJP government, who are now also judges, who continue to rule not based on the facts or evidence in front of them, but purely rule based on their ideological premises. Second is the creation of something called the NIA, the National Investigative Agency. The National Investigative Agency was created in 2008 after the attack on the parliament as a counter-terrorist task force. So, and what is really important to understand is that the Indian state is using a counter-terror task force. And who is it targeting? It is targeting the country's rights defenders. It's targeting scholars, writers, thinkers. And what is really essentially important is also the men who have been put in place in organizations like the NIA. Its former secretary was Mr. Y.C. Modi, again, a man who was appointed by the current regime, who has also had his hand in previous investigations like the one in Gujarat. And the current head, Dinkar Gupta, again, was a man who was put in place, again, created, he's told that the reason he was put in place is that he has expertise dealing with terrorists. I think another thing that we really have to understand is that these are institutions that were fundamentally using what we call terror and sedition laws. And these laws are directed again at scholars, writers, and thinkers. The third thing that we really have to think about is the role of the judges themselves. Despite the existence of laws like UAPA and NIA, lower courts and the higher courts and the apex courts all have within them enough rights to adjudicate on the principles of evidentiary rules and others, but they've actually acted more as an extension of the state and its beliefs rather than actually ruling on the law. And what we really have to think about the BK16 case is that while there's a long history of repression and abuse of laws in India, we have to see the BK16 as a model of repression. What was started much before BK16 was perfected. And what did the BK16 perfect? One of the things that the BK16 really perfected was manufacturing of fabricated evidences and use of surveillance technology to plant information on the BK16 activists. Before I go in, I just want to very quickly give a brief introduction of who the BK16 are, so that for those of you who are encountering them for the first time have a little bit of context. So BK16 are 16 individuals across India who were arrested. The arrest started on the 6th of June, 2018, under UAPA or the terror laws. And then they continued on as staggered arrests as more and more activists were picked up. The last arrest was that of Father Stan Swami. And what really happened with these arrests is that, what were they charged with? All 16 of them have been charged with acting on behalf of being members of the outlawed Communist Party of India, plotting to assassinate the Prime Minister of India, and making inflammatory speeches at the Elgar Parishad. Again, in all of these cases, if we actually look at the evidence in front of us, there are two kinds of evidence that has been published, two kinds of evidence that has been put by the ruling party and the courts and the police. And both of these evidence are one, either they are fabricated, manufactured, or in most cases, information that was placed within these computers. An agency called Arsenal conducted independent forensic analysis of the material that was found with many of these activists, and they found two things. Computers of these activists were compromised 22 months before the arrests, and the attack was intended for two reasons. One was surveillance and planting of incriminating documents that was using remote access. And the top 10 of the documents used in the charge sheet against Rona Wilson and the other BK16 political prisoners were all planted by the attackers. For each of these 10 documents, arsonists were able to identify the time and the date of creation and the specific session used during these files planted. And one of the things that Arsenal concluded in all of this was that whoever made this attack or created this attack 22 months before the arrests had resources. This attack was deliberate, meticulously planned by a well-resourced agency. And Arsenal characterizes this attack as one of the most serious cases of evidence tampering. So what we really have in front of us is not only a system that uses draconian laws, we have a system that manufactures evidence, fabricates evidence, and then puts it in front of a judiciary, which then, despite having enough information to adjudicate, then decides not to. The other feature of the UAPA laws is that it, as I said before, made bail almost impossible, which means that a bail hearing itself then gets turned into not so much an adjudication of the facts in front of them even for the bail. What it really does is that it creates every single engagement with the judiciary as a kind of a kangaroo court. But the judges, rather than pronounce on the legality of issues, then go on to pronounce on the political nature of evidence, which they are not supposed to do. Again, as I said, these become kangaroo courts. Another important aspect of the BK16 case is not only the ways in which laws and institutions and individuals are then weaponized to criminalize dissent. What we're also seeing now is the absolute ways in which this impunity becomes entrenched as a part of the law and the legal system. And I think I want to conclude by something that the American Bar Association report actually made. And one of the things that the American Bar Association very clearly said in its analysis of the material in front of it was this. It said that the judicial records in this case raise serious concerns of procedural irregularities, abuse of process, and violation of fundamental rights. And again, the core idea that we need to take away from the BK16 case is not just the 16 individuals, because we know the names of these 16 individuals and we get to speak about them and talk about the illegalities that was inflicted on them. What we have to really understand is that this is a model that is going to be used and reused over and over again to criminalize dissent. We already saw this with the Delhi 18 case, when the violence in Delhi was unleashed, and then 18 others, students and activists, were picked up. I'm going to quickly conclude here, but again, with reiterating the point that we really need to look at the BK16, not just as an individual case, but as a long history of erosion of civil liberties in India. Thank you.
Thank you. And now we'll turn to Dr. Waris Hussain.
Thanks, Susan. Good morning, everyone, and thank you to the International Law Committee for hosting this very important discussion today. I'm going to keep my comments rather brief because the remaining panelists we have personal stories to share of people who they love or are very close to who are facing imprisonment or have actually died in the process of this adjudication of these criminal charges. I think their stories are the far most important here to be told today. But as legal advisor for the ABA Center for Justice, the Justice Services Program works in Asia, of course, and we have several programs open in India, including a fair trial report, which was cited to earlier on today, which we produced on the Bhima Koregaon case itself. We've been involved in the case and monitoring it for the last 2 years, 3 years. The Center for Human Rights at the ABA provides pro bono legal assistance and conducts international legal advocacy for human rights defenders who are facing persecution or prosecution due to their work. In that vein, the center has worked on several cases that involve human rights defenders in India, from student leaders to lawyers to journalists. And the consistent theme of the work in India remains that the increasing level of challenges and retribution that activists and civil society leaders face due to their advocacy is only increasing over time. It is not decreasing. While in a healthy democratic order, dissent like this is protected from any kind of punishment, India has increasingly seen a level of repression for human rights defenders that is historic. This repression takes many forms, but in particular for today's purposes, we'll focus on the criminal charges being lodged against activists in order to silence them and methods used by the state to pursue these charges. Outside of the law, there are many other ways in which human rights defenders are being repressed and are being sort of punished by the state, which include sort of harassment and other forms of non-judicial or non-legal means of repression, but those are happening. But today we'll focus for the Bhima Koregaon case in particular on the in-court challenges that human rights defenders are facing. So to begin, as we've seen in the Bhima Koregaon case, essentially the story is that this is a group of activists who were championing the rights of the Dalit or the untouchable community and have faced several years of pre-trial detention and are facing serious charges relating, as was discussed earlier, to sedition and terrorism. The first of the many challenges faced by human rights activists who face criminal charges like the UAPA, which was mentioned earlier, or criminal charges that relate to sedition or terrorism, is that these laws allow for pre-trial detention of human rights defenders. So for example, if it comes to sedition or unlawful activity, the authorities can continuously hold a defendant in detention without proceeding with the criminal case in chief, without having the prosecutor do what they're supposed to, moving the case along in a prompt way. So essentially, they are able to hold these people in pretrial detention without proceeding with their case, which could take several years, as we've seen in some of the Bhima Koregaon cases, to move ahead. For many of the Bhima Koregaon accused, years have gone by without the criminal case proceeding through its stages. This essentially means that, or amounts to, the process of the criminal justice system being the punishment in and of itself for the human rights defender. So even if the government can't successfully attain a guilty verdict, they can punish a human rights defender with a multi-year process during which they will be held in detention and will not be able to be released because of the way the laws are structured. In that regard, I'd like to read from you a statement from the president of the American Bar Association that relates to this case. In May 2021, President Rifo of the American Bar Association said, and I quote, "The American Bar Association is deeply concerned about the continued pre-trial detention of minority rights activists, advocates in the Bhima Koregaon case in India. As many of the accused are over the age of 65 and have serious medical conditions, these activists are at a high risk for contracting COVID-19 as India deals with substantial surge in cases. The Bhima Koregaon case involves 16 individuals known for their advocacy in support of disenfranchised communities such as Dalits. They are facing criminal charges and they have been in pretrial detention for more than 2 years. In 2019, the ABA Center for Human Rights released a preliminary fair trial report examining the prosecution of the Bhima Koregaon activists and how this violates India's laws and its obligations under international law. Defense counsel for the activists have submitted applications for pretrial bail at many courts, including the High Court. As these courts assess bail applications, the ABA respectfully appeals to the Indian courts to ensure that the defendants' fair trial rights are fully protected and end their prolonged pretrial detention. So this was a statement that was given by the American Bar Association president. At the same time, there were many statements given by the International Bar Association presidents, the Commonwealth Bar Associations, many people in the legal field spoke out, have asked or requested for the government to release the activists. Yet, despite the advocacy from all of these international fora, the government has not withdrawn its cases against these individuals. As will be discussed shortly, one of the defendants even died in prison from the charges that they were facing. The last thing I'll mention in terms of the specific elements of the case itself, Digital investigations, as was discussed earlier by independent researchers, have found that in the case of the BK16, the digital evidence being used against the defendants is not authentic. Some fear that, in fact, the digital evidence was planted, as was discussed earlier, and this is particularly frightening as the courts in India are increasingly becoming digitized and allowing for the use of digital evidence to be admitted in criminal cases. Yet, if evidence can be falsified and still be used to imprison activists under pretrial detention or to actually get a conviction under the UAPA or other laws, the future of human rights defense in the country is in very serious danger. And that goes far beyond the 16 and 15 individuals who are currently facing criminal charges. And these kinds of legal cases have not just been lodged against the BK16. There are other cases across the country of human rights defenders facing serious criminal charges in response to their opposition of the ruling government. The tide is pushing against activists and the democratic institution of opposition. And a growing silencing can spread when potential new activists are seeing their mentors, their colleagues, their professors, their teachers facing serious criminal charges and several years in pretrial detention due to their work. So you have to think about what the impact for young activists, the next generation of activists will be when they see this kind of behavior from the government against people who they hold as mentors or as people who are helping them learn more about this area of human rights defense. The pushback against this tide will play out in the political fora, but the importance of an independent judiciary and lawyers cannot be understated in this instance. India and its Supreme Courts have had previous periods of serious independence where ruling governments were afraid of the Supreme Court overturning their activities if they amounted to a violation of the Constitution. In the past, India's judiciary was a par excellence for judiciaries in the global South. However, today, we have seen that the justice system is facing severe difficulties in India, and the judiciary is not pushing back as actively as it once did against the ruling administration, especially when it's conducting anti-constitutional or illegal actions. We've seen several cases being Supreme Court, including challenges to pretrial detention of the Bhima or the BK activists, where the judiciary has granted deference to the ruling administration. And without protection from the courts, activism, human rights defense, the democratic order, and the rule of law in India face an existential threat from the current political ruling administration, who views these individuals as not parts of a democratic order, but as challenges to their increasingly growing authoritarian control over the country. So I'll conclude my remarks there because I think the remaining panelists have very personal stories that are going to be particularly important to leave aside some of the legal jargon that we've just talked about and that I've just talked about, and to understand the actual human element of this story. I'm very happy to have these other panelists here speaking. So I'll defer the time, Susan, for them to deliver their remarks.
Thank you, Dr. Hussain. And now we'll turn to Dr. Jenny Rowena.
Yes. So, hi everyone. I am Jenny, and I am Dr. Hani Babu's wife. Hani Babu is teaching in Delhi University. He's an associate professor there in the English department. So he was a very active part of the university. He was actively involved in a lot of issues related to marginalized students and teachers. And he himself is from a Muslim OBC, which is a marginalized group community. And people used to come to him for help. And he also had taken up a lot of legal issues with the university and fought for the rights of the marginalized within the university. He hardly had any activities outside the university, and everyone knows what his activities were. It's all out in the public. So everyone knew about his activities, and he was not associated even with the conventional left, let alone the radical left. So it's very clear to people in the university that who Babu is and what he stood for and how he's not in any way connected to all of this. Yet they have been able to put him in prison for the last 2 years. He was arrested on July 28th, 2020. and he's still in prison. The charges have not been framed. And the thing is that how they have gone about this arrest is, as it was discussed earlier also, that they have just found evidence in his computer. There's nothing other than the evidence that is there in his computer that has led to his arrest. And this computer they took after raiding our house a few months before, that is in September 2019. They raided our house and they took away his computer. And then in July, they called him for a interrogation. So they kept him 5 days. They kept him in Mumbai. They allowed him to stay in a hotel, but every day he had to go for this interrogation. And during the interrogation, they tell him that there are these documents on your computer. Other than these documents, there is nothing, no activity or anything. He has not done any crime. All that he has been accused of, even in the official charge sheet, is that these documents are found, and these documents prove that you are a Maoist, which is a member of a banned organization in India. Other than that, there is no proof of him, attending a meeting or anything. Any real life proof is not there. And then things like emails that have been sent to him, forwarded to him, have also been used as, which he has not forwarded to anyone else, which he has not replied to even. That has also been used as evidence against him. So the thing is, and when they took away this computer, when they raided our house, there was no official protocol that was followed. Actually, there is no official protocol that exists. For at that time, we did not know about hash value and stuff like that. So they just took it like they would take a gun or a book. They just put it inside a plastic cover, sealed it, and took it. But a computer can be tampered with even when they are examining it. So actually this evidence, that this so-called evidence, is also not, if you look at it in the long run, it won't be admissible, because there can be stages of tampering. And even the forensic report, they have not said anything about the tampering. They have not answered the question about whether the evidence has not been tampered with. So based on these kind of flimsy evidences, he has been in prison for 2 years, and the other people in the case more than 5 years now. And all of this is also caused because of this Unlawful Activities Prevention Act, the UAPA, the law which allows the courts to go by the police story and keep the person in jail without giving them bail. So this is the law which has actually come out as a global response to terrorism itself. But in India, it is not the terrorists that they are framing with this. And lots of such activities, Hindu majoritarian activities keep happening, but none of it, UAPA is never used in that context. Instead, UAPA is used to, trap people like my husband and the people in this case, and also in other cases where you have protesting students, you have journalists. So these are the people who have come under the ambit of this law. And given the nature of this law, even though the police is saying that Babu got an email which had an interview sent by some terrorist organization, which had an interview with some other Maoist leader, even though that is a claim which doesn't prove anything, because Babu's email is in the public realm. Anyone can send him an email, and he has not done anything with it. He has not replied or forwarded, nothing. So they are claiming that he has connections with that terrorist organization just based on that one email, which was found when they took his computer. So even that will not really eventually stand in court, but still you'll have to stay in jail without being given bail, which is a very serious his rights are being seriously they're not being given his human rights here. This is what is happening in this case. And the thing is that he's a university professor, somebody who usually we think is kind of insulated from these kind of charges. But the fact that now that arsenal reports have come in many cases, not just one case, in more than one case in this in this Bhima Koregaon Elgar Parishad case, which tells us that the emails, the documents found in the computer could have been planted. Now that it has come out, it is a very serious thing that, you know, they can actually plant documents in people's computers, then raid their houses, take away their computers without following any protocol, and then using the UAPA, they can put them in jail. And what really is happening, I feel, is that this is a kind of, you know, this is a kind of, these 16 people are like scapegoats. They are like made as an example to show India. For example, the university at present in Delhi, the University of Delhi and all universities under this regime is going through a huge change called a new education policy, and a lot of changes are going to happen. So this is like a warning to the other teachers also that, you know, if you are going to resist, if you are going to protest, if you are not going to toe the line of the government, then even a person like Hani Babu, who was known to be such a decent, such a good person, who used to help everyone and who people used to go, you know, used to be a shelter for marginalized students. Even such a person with such an impeccable public record can be put in prison. So this is the big message that the government is sending out. And this is a way to stop all kinds of voices, all kinds of resistance, and to bulldoze their way into implementing any kind of policy they want and getting away with any kind of anti-people policies they want. Even in the other case, even the other people in the cases, each of them has a public track record of fighting for rights of the marginalized, standing with the marginalized, giving legal cases for the marginalized. And this public record is not at all important now. It doesn't matter who they are as have been. Some document is telling some other story, and the courts and the police and everybody is just, you know, using this concocted story to just throw them in prison. So this is like literally like when we used to have the emergency during the Indira Gandhi era. This is just an undeclared emergency that is happening in India. And I think everyone should take serious note of this, because this not only punishes people, but it also spreads this fear about doing anything, resisting, talking, and everybody is trapped in this fear, because it is happening to people we know. It is happening to people who are supposedly powerful and who has all the resources. And if that is so, then the most marginalized are in even worse situation. So this is just a clamping down of all kinds of resistance. And this is just a silencing. And this is it has made a huge toll on the family also. And the students are really feeling hopeless, because here is a favorite teacher. When our house was raided, the next day there was such a big spontaneous protest for him. But when he was arrested, it was COVID, and people could not even come out to protest. And even the very few who were protested, they were slapped with epidemic and some COVID related laws, and they were, you know, harassed. So students are also very lost, because Babu used to teach language. He's a linguist basically, and he used to teach about language, connect each of the students to their own regional languages. And he used to question the hegemony of Hindi, which is very dominant in the Indian this thing. And talks. So he had a very different approach. He was a very important, significant teacher in the university. He came in through the reservation affirmative action policy, and it was very important for him to be there. Every day I see students who tell me how much they miss his classes and how much of a loss it is for them, how the department is suffering because it's now not able to cater to these people from the marginalized group for which Babu was a support. So they have actually done away with a person's social career. It's not just a career as a personal thing, but it's a social thing that he was doing. They have just put an end to it. Like now, we don't know when the trial will happen. There's the charge sheet itself is, he was saying that it comes up to his neck. So he's very tall. So the charge sheets itself is so huge. The number of witnesses are so huge. The trial will go on for years. and then he has to be acquitted, and then only he can go back to his job. It's literally like putting an end to his job. And for no reason, for nothing that he has done, this is a serious violation of our rights. And this is a serious issue that is happening in India, where resistance is just being shut down without following any due process. And there is really no voice against this. This is what I have to say. Thank you.
Thank you, Dr. Jenny. Dr. Jenny Rowena, and now we'll turn to Father Joe Xavier.
Thank you, Susan. Thank you, friends, for this opportunity. As Susan introduced, I am a Jesuit priest. And you know, Father Stan Swami, he has been a Jesuit priest all along. Stan Swami was the last one to be arrested in the BK16 case, the 16th person, and died as under trial in an hospital. What did he do? Jenny spoke about Hani Babu, and I'll say something about Stan, why the state targeted him. Stan committed his life for the well-being, development, and rights of the Adivasis, who form the indigenous communities in the central part of India, Jharkhand, Chhattisgarh, Madhya Pradesh, Orissa. And he gave his life to become a voice for these Adivasis. You know, these Adivasis usually are considered as people who don't have much education, healthcare. They live in the forest area. They depend on the forest and the land and the water. And the Constitution provides special privileges for the protection and promotion and development of this community. So Stan's idea was to become a voice of these people and make sure the state, the lawmakers, and the law enforcement agency apply these laws and help these communities to develop. That was his only aim. And it is, unfortunately, it is in this Adivasi or the tribal indigenous communities, you have rich natural resources. You call any mineral, coal, bauxite, iron, gold, everything is available in plenty. And these indigenous communities were sitting over them. And you have a modern development process that's happening. And most of the corporate companies go there. They just, in connivance with the state, they overthrow, they displace, they chase away the Adivasis so that they can grab the land and excavate the minerals in the name of development. All that Stan was demanding was the people also should be part of the development process. So obviously, he wrote about these issues in the papers. He was with Parkinson's. He could not even hold his tea or food. So, but with all that struggle, he became a voice of the voiceless indigenous communities. He also made a study of that state, going to the prisons. Who are there? Because he heard a lot of Adivasi youth are languishing in prison. He made a study, research, and found out over 3,000 Adivasis are languishing in prisons as under trials for 1 year, 2 years, 3 years, without a trial. Not even a charge sheet has been filed. He filed a public interest litigation in the Jharkhand High Court in 2018, asking the court to direct the state to verify every case. If there is no evidence, to release them. If there is an alleged offense, then go for a trial so that the justice process comes to an end. That's where the state got angry. Who are you to tell us? We will show you our color. And that's where state started targeting. But still, Stan, being a Jesuit, an ethically, morally upright person, very strong, he was not afraid of arrest. He was not afraid of being tortured. He always wanted to speak the truth and truth to the power boldly and courageously. Even when he was in prison, he wrote, "A caged bird can still sing." That was his verse. And even from the prison, he wrote a poem which I published it in the public domain, Light, Hope, and Love, the New Order. And he concludes the poem by saying, but fight we will till the end, not so much to save our skin, but to speak truth to power, counting all the while you are all with us in mind and heart. So he was building people's strength, confidence, so that as citizens, we can live a decent, dignified life. While we may be deprived of education, health, but let's have a decent, dignified life. That has been his struggle all along. Now, with all that has happened, I'm not going to the details of it. I just want to highlight a couple of lines, which, after listening to all these allegations, opinions adopted by the working group on arbitrary detention at its 92nd session, 15 to 19 November 2021. I'm sure, friends, you are aware of the working group on arbitrary detention. It was presented in the Human Rights Council in Geneva. There, they made the statement. I just want to highlight what they have mentioned in the report. This report is available in the website, in the UN website. In a 13-page document, they conclude, the working group expresses great sadness that Father Stan Swami died due to COVID-19 on 5th July 2021 in custody, while arbitrarily detained in circumstances that were utterly preventable. They go on to say, Father Swami, a renowned human rights activist who had dedicated decades of his life to fighting for social justice, paid the ultimate price for his activism, his own life. United Nations human rights experts have said that Father Stan Swami's death in custody will forever remain a stain on the human rights record of India. The working group agrees. The working group would welcome the opportunity to work constructively with the government to address arbitrary detention. The working group would welcome the opportunity to conduct a country visit to India and looks forward to a positive response to its request for a country visit dated 22nd February 2018. This government does not honor any such request. And in the disposition, they've said, in the light of the foregoing, the working group renders the following opinion. The deprivation of liberty of Stan Swami being in contravention of Articles 2.1, 9, 19, 25, 26 of the International Covenant on Civil and Political Rights and 2, 3, 7, 9, 19, 21 of the Universal Declaration of Human Rights was arbitrary and fell within categories 1, 2, and 5. The working group considers that taking into account all the circumstances of the case, in particular, the death of Father Swami in custody, the appropriate remedy would be to accord his family an enforceable right to compensation and other reparations in accordance with international law. And I'm here to say the family does not require, but this reparation and compensation must reach for a good cause of the Adivasis. That is what we are demanding from the court. The working group urges the government to ensure a full and independent investigation of the circumstances surrounding the arbitrary deprivation of liberty of Father Stan Swami and to take appropriate measures against those responsible for the violation of his rights. I will give you a couple of examples. Taloja is one of the biggest prisons. In the prison manual, it is said how many allopathy medical doctors are to be available, but no one is available. Despite the COVID-19 pandemic, they have been targeted without any medical care. This has been the scenario. This is on the one side. Now, I will come to the Arsenal report. The Arsenal report, I'm sure, Arsenal Consulting Agency, how systematically these people have been designed, roped into a well-designed targeting. Now, Arsenal very clearly brings out Stan's computer was fiddled, was interpolated from 2014 to 2019. 5 years. Imagine an elderly Jesuit who doesn't use laptop, an old desktop computer, there they've got it. And I'm going to make a statement, even God could not save him, because generally they went with a design, go capture the computer, we go put everything. That seems to be the design. They went for the first raid in 2018. Fortunately, unfortunately, a week before, the desktop computer that he was using was under some repair had happened. The Jesuit who was staying there said he removed it and gave him a new laptop. So during the first raid, the investigation officers went there, just took the laptop, we got it. So they went back. But they knew that was new. They realized after a year, nothing was there. Again, they come back in 2019, made sure till 11th June, somebody was fiddling from outside using a malware, and 12th June, they take it away. So in all that, we could really understand it has been the planned strategy, targeting Stan, because he gave voice to the voiceless, the Adivasis. But unfortunately, Stan is not there to prove his case. When the investigations officer showed all these letters, these were found in the computer, he asked them, tell me who sent it, which date, to whom it was addressed. They said nothing. We know now it is all been interpolated, but using an external malware and inserted. Now, which means they are connecting this case with Elgar Parishad, a one-day violence that took place. That's a separate issue. But take this case from 6th June 2018 to 8th October 2020, the last arrest of Stan. The government has taken literally 2.5 years, 2 years plus 5 months, targeting 16 people to send out a message to the public. You are under watch. We can do whatever we want because the weapon called UAPA, Unlawful Activities Prevention Act, gives us an ammunition to target anybody and everybody. Look at this contrast. Stan dies in prison. Then we had to cremate him. On the next day, while the central government and the agency has been targeting the state government, the chief minister of Jharkhand, where Stan was working, he goes there to pay a tribute and says Stan has been truly an Adivasi activist. Because this chief minister is not from the central government party, from another party. He himself is an Adivasi, Hemant Soran. He attributes Stan has been truly an Adivasi activist. Look at how the power centers observe, make comment on a particular person. Now, all that before I conclude, I want to say what's happening in the country. Stan is an example. BK16 is again a test case, but it is happening all across. Many of my friends who are human rights defenders are completely targeted. The central government agency has determined to instill fear among all these and thrive on a Hindu Rashtra agenda by instilling fear across everybody. Stan was a test case to send out a message to the central provinces, where the minerals are there. If anyone opposes our corporate agenda, you are going to be targeted. So what do they use? They label these people as bad, as urban Naxals. So first they start with a labeling. Second, they start demonizing. Why do I say labeling, demonizing? Imagine when Stan's death happened, I was there in Bombay having a funeral Eucharist the next day, and it was a COVID time where there was very minimum people in the church. The next day in the High Court, the High Court judge, one of the High Court judge who was hearing this case, Justice Shinde of Bombay High Court, he made a generic comment in the court. Usually I don't watch TV, but yesterday something triggered me. I watched the funeral service. It was such a meaningful service, and I came to know how much he worked for Adivasis. That's all. He made a statement. From that evening, in the name of Hindus for Human Rights, an RSS affiliated, BJP affiliated group started trolling him, went to the extent of demanding the president of India to impeach him from being a judge. As a result, after 4 or 5 months, he recused himself, saying, I can't hear this case because if I say anything, there are people there to attribute motives. Look at this. After that, Bombay High Court formed 5 different benches. Every High Court bench is recusing themselves and nobody is willing to hear this case. This is the sad irony or sad status of the High Court of Bombay. If we can't go to the justice system, to High Court for justice, where else we go? You don't listen to the Human Rights Council, the Arbitrary Detention Committee. You don't listen to Arsenal. You don't listen to the High Court. You threaten everybody. You label these people. You demonize and you eliminate them. Is there no voice to check and ask you for justice? This is my request. And what is my appeal to you? Today, we are really living in a helpless situation. Fortunately, today in the Supreme Court, some small light is happening. In one of the benches, they've asked regarding two other accused in the Bhima Koregaon case, where Vernon Gonsalves, Arun Ferreira, two other people who are accused, alleged, and still they are prison. Their bail petition has come. Today, the Supreme Court has asked the prosecution, tell us on one instance where you have the evidence that these people instigated or asked people to take up arms to say they are Maoists. No answer has come. It's going to be heard again on 3rd March. So there is all around fear, helplessness. Your voice will count. Your voice will be a solidarity support for us, so that human rights is not a domestic issue. Human rights issues cannot be just restricted to a nation state, but I think it's a global concern. And I expect your voice will add strength to us so that we all become the human rights defenders of the globe. Wherever the rights are violated, wherever justice is denied, we are able to raise the voice on behalf of the poor and the marginalized. BK16 stands for me are only test cases, but there are many others who are living, still continue to struggle for human rights. I think it's time to join hands, give voice, become voice, so that people who need justice will get justice. Thank you so much.
Thank you so much, Father Joe. We have questions from the audience. Do you know if the EU or another third government is providing support, for instance, by their embassy staff sitting in the trial or speaking with the lawyer? This is what they publicly claim they do. Are they following through?
My understanding is that they oftentimes are, but it doesn't matter. It doesn't make any difference to the Indian government. They've only calcified their position even more. The more the embassies go, the more the Indian government digs in its heels, it feels like. Sometimes there aren't observers there, but I know for a fact in many instances, for some of the cases, embassies like the US, UN, EU and other member states of the EU have sent trial observers and have said they were sending trial observers, and they've probably privately raised this issue with the Indian government, just like the working group on arbitrary detention that Father Joe was talking about approached the Indian government with all of their findings and told them, we know these things. The response from the Indian government is calcifying their position and saying, absolutely not, we're not going to change anything about this case, and we're going to even go further and harder against these people. So I think there's another question from Regina as well. What can we do? I mean, the only thing we can do is keep putting pressure on our governments, the US and EU governments in particular, to keep raising this with the Indian government, but that's only so it doesn't get worse. Really, to remove these charges or anything else, the Indian government is not moving. And I'm not sure what we can do to force them to move, but certainly what we've done up till now has been consistently happening, and there are engagements from those folks, but it's just the Indian government's response from international advocacy has been very poor overall. I'm not sure if Father Joe or Dr. Jenny have an alternative opinion on that, but that's what I've seen.
Yes, I will put it this way. Number of European parliamentarians or the embassy people have been expressing solidarity support. We have requested them concretely, one, you can meet the people, the family people of the BK16. You can also send your observers to the court to see what is happening, report back, but there is always a hesitation on their side, except one or two who are willing to walk that extra mile, they hesitate. And they privately admit it is, yes, human rights violation, but there are business interests, and the Indian government is seen as a big brother by the global community, and we are struggling. Honestly, they tell us this.
What more can we in the ABA do to help, since there's already a presidential statement and the CHR report?
I mean, our plan is to continue to follow it and to put as much pressure as we can. I think, like I said, the objective for us isn't moving the line, because it feels like that might not happen back, but definitely keeping it so that they don't go further. And then especially with prison treatment, if there is a backing off by the international community or pressure from the ABA or other places, the treatment of prisoners can become much, much, much worse. As we saw in or Father Stan Swami's case, it can lead up to death for that person because of the negligence or the actual, attempts to end the life of a prisoner. So I think we have to maintain our pressure. We have to keep putting pressure on. I think Father Joe mentioned that getting more observers in the trial proceedings, we can push on embassies to do that. We're going to continue to do that. But I think our objective here is to not let them push too far back into the place where almost all the defendants are surreptitiously disappeared or killed. That is something that the international pressure does keep that from happening. But in terms of the charges being dismissed from international pressure, I'm unsure what we can really do beyond that.
I want to thank you. I want to say thank you to each of our speakers. This has been a very moving and difficult subject. You're shining a light on an issue that is extremely significant to all of us, to lawyers worldwide, and to the human rights community. And thank you so much for sharing your personal stories of the people you care about and love. I want to thank each of our speakers, Suchitra Vijayan, Dr. Waris Hussain, Dr. Jenny Rowena, and Father Joe Xavier. If you do have suggestions, ideas for how we as lawyers, as individuals, as humans can help, please let us know, and we will make sure to continue to shine a light on this issue.
Thank you. Thank you.